sentences for the scheduled crimes that are consistently heavier than before. This was in 2002, my lady. Even though the judgment of Abrams is 2002. Even if the court would find compelling substantial circumstances, the clean slate then entails, my lady, that it should be consistently heavier than before, if the court would find that. But I think, and I say it with the utmost respect, paragraph 36 is of importance. In Directive Public Prosecutions, North Gauteng versus Tabete, 2011 decision, the Supreme Court of Appeal observed that Section 51.5a precludes a sentencing court from wholly suspending a sentence imposed in terms of the Act. Lady, if I refer to Tabete, paragraph 23, it's at page 578 of that specific judgment, it reads, it's true that Section 51.5a of the Act precludes a sentencing court from suspending a sentence imposed in terms of this Act. It follows that the court below erred in having a sentence wholly suspended. So, lady, the sentence that the court would think of in terms of the starting point, which is 15 years, there's no clean slate, we start at 15 years, cannot be wholly suspended, my lady. My lady, we refer to Rosli. Then, my lady, from paragraph 38, we deal with the traditional factors to be taken into account. I will not spend a lot of time on that, my lady. We all know the triad factors in Zin. What I, however, want to just pause at, my lady, is in paragraph 39. At paragraph 39, in the Rabi judgment, and may I quote from paragraph 39. The appellant Judge Appellant Holmes defined the element of mercy as a balanced and humane quality of thought which tempers one's approach when considering the basic factors of letting the punishment fit the criminal as well as the crime and being fair to society. Holmes J.A. pointed out that mercy has nothing in common with maudlin sympathy for the accused. It was moreover affirmed that it would be wrong first to arrive at an appropriate sentence by reference to the relevant factors and then to seek to reduce it for mercy's sake. And the way I understand the judgment is if the court would think that a fitting sentence would be 15 years, the court won't think 15 years and now I'll apply mercy. The mercy will be applied in arriving at the sentence, my lady, and not subtracted to what the proper sentence would be. A bit further in that same paragraph, my lady, we refer to Damora. Appellate Division observed in this respect that the question of mercy should be seen primarily in contradistinction to and as a corrective for a tendency towards callous and arbitrary vindictiveness in the sentencing of offenders. But nevertheless, the consideration of mercy should not justify any suspicion of a desire to condone or minimize serious crime. My lady, further, in the same paragraph, paragraph 39, we refer to Rabi, where Rabi summed up the role of mercy, my lady. The court found a judicial officer should not approach punishment in a spirit of anger, because being human, that will make it difficult for him to achieve that delicate balance between the crime, the criminal, and the interests of society, which his task and the object of punishment demand of him. Nor should he strive after severity, nor, on the other hand, surrender to a misplaced pity. Pity will play no role in the sentence, my lady. And we refer in paragraph 40, as we deem it proper, to Samuels as far as mercy is concerned. In paragraph 41, my lady, we discuss the decision of Director of Public Prosecutions KwaZulu-Natal versus P and S versus de Villiers, my lady. In both P and de Villiers decisions, the court observed further that to such element of punishment must be added the quality of mercy as distinct from mere sympathy for the offender. And we defer further to Ter Blanche, my lady. In S versus Swart, in paragraph 42, we go through the case law, my lady, because we want to emphasize that it's not a clean slate. The minimum sentence legislation is applicable. And even if the court would find substantial and compelling circumstances, the decisions directing what then would be a sentence and what would be expected of this court. So, my lady, in paragraph 42, we refer to S versus Swart. We respectfully submit that in Swart, the Supreme Court of Appeal, per Nugent J.A., and a full bench of that court held that in our law, retribution and deterrence are proper purposes of punishment, and they must be accorded due weight in any sentence that is imposed. Each of the elements of punishment is not required to be accorded equal weight, but instead, proper weight must be accorded to each according to the circumstances of the case. Serious crimes will usually require that retribution and deterrence should come to the fore, and that the rehabilitation of the offender will consequently play a relatively smaller role. Lady, and that's our argument. We're dealing with the court convicted this accused, the trial court, of Kabul homicide. And in that judgment said it was a very serious offense. It's now murder, my lady. It's more serious. We've now had the aggravating factors by the SCA. We have that linked to the factors that this court found. We're dealing with a matter that is severe, that's very serious, and we argue that the rehabilitation of the offender will play a relatively smaller role. We've heard Professor Skoll's evidence. His evidence, and he agreed. He admitted that he focused solely on the accused, on what kind of person the accused is. We also know that although he was handed a document highlighted by the defense about aspects that would not fit into his report of the violent actions of the accused, he just ignored that. My lady, the mere fact that that particular report by Dr. Bayi was not given any prominence in the report of Professor Skoll's affects his objectivity, lady, and clearly indicates his bias. My lady, this court dealt with Karg. We've dealt with Karg in our earlier argument. May I refer to paragraph 43, where the finding of Karg was quoted with approval in a more recent Supreme Court of Appeal decision, Director of Public Prosecutions, North Gauteng versus Tabete, where the court added, it's trite that one of the essential ingredients of a balanced sentence is that it must reflect the seriousness of the offense and the natural indignation and outrage of the public. Lady, in paragraph 44, we deal with the fact that it's the duty of this court not to follow public opinion, but to lead public opinion in its sentences. Matlakaza is a matter that we refer to, where Harms J.A., as he then was, my lady, for the court observed that the object of sentencing is not to satisfy public opinion, but to serve or to lead public opinion or the public interest. The court added, sentencing policy that caters predominantly or exclusively for public opinion is inherently flawed. It remains the court's duty to impose fearlessly an appropriate and fair sentence, even if the sentence does not satisfy the public policy. My lady, in paragraph 45, we refer to Rabi and Strauss, where they note that punishment serves the public interest by discouraging a repetition of the offence by the offender and the perpetration of similar offences by others. Lady, may I pause here again? In Mr. Steenkamp's evidence yesterday, he was at pains to say that he would want people to see what the deceased, what injuries this accused caused to his daughter, to the deceased, so that other people will not do this again. My lady, what this court can do is to, in its sentence, ensure that people would not act as this accused did, arming himself, deciding to shoot an intruder whilst he's still in his bedroom, walking to a bathroom without any danger to him, firing 4 shots in a small cubicle. A sentence by this court should deter people from acting in that way, my lady. My lady, we have focused, and I want to focus on the interest of the victim or the victim's family. My lady, in a murder matter, the victim is deceased. A lot of these cases that would refer to sexual offences, but the principles in those matters apply in this matter as well. My lady, the victims in a matter like this must be the mother, father, and family of the deceased. And they have certain rights that we believe in the last couple of years have come to the fore and should get the attention it deserves, my lady. We say in paragraph 46, it's respectfully submitted that it's important to bear in mind that the traditional aims of punishment have been transformed or affected by the Constitution. It's respectfully submitted that in line with the values enshrined in the Bill of Rights, the interest of victims of crime must be added to the traditional triad factors in considering an appropriate sentence. It's submitted that with the advent of the Constitution, the victim must be afforded a more prominent role in the sentencing process, and indeed, a suitable sentence also needs to be victim-centered. We refer to Machichi, my lady, there is a long quote from Machichi where the court dealt with why it was important to be more victim-centered. We've highlighted some paragraphs where the court discussed the UN Declaration of Basic Principle of Justice for Victims of Crime and Abuse of Power. And may I just focus on the paragraph, the last paragraph, where it reads, the victim is thus afforded a more prominent role in the sentencing process by providing the court with a description of the physical and psychological harm suffered, as also the social and economic effect that the crime had and in future is likely to have. By giving the victim a voice, the court will have an opportunity to truly recognize the wrong done to the individual victim. My lady, we had a victim here that gave evidence, that broke down, that will never see his daughter. She will never walk again. He will not see her again. He talks to her every day. He looks at photographs of her. He's almost become a recluse. He's done nothing wrong. The deceased has done nothing wrong. This accused murdered her. This is what this court has to sentence. Lady, in paragraph 48, we deal with Machichi and the reasons why the interests of the victims play a more prominent role, my lady. We quote, by accommodating the victim during the sentence process, the court will be better informed before sentencing about the after effects of the crime. After effects, my lady, there's not a day going past that I think of the deceased. Everywhere I go, I'm confronted by what's happened. I will never get over it. That's the evidence that was led. I will never get over it. The court will thus have at its disposal information pertaining to both the accused and the victim, and in that way, hopefully, a more balanced approach to sentencing can be achieved. More balancing than a report by Professor Scholz indicating what is good for the accused. My lady, in the last paragraph, it is thus important that information pertaining not just to the objective gravity of the sentence, of the offence, but also the impact of the crime on the victim be placed before the court. That in turn will contribute to the achievement of the right sense of balance, and in the ultimate analysis will enhance proportionality rather than harshness. My lady, we refer in paragraph 49 to Tabete again, where the court found, where in Tabete it was reaffirmed, my lady, that it admits of no doubt that in determination of an appropriate sentence, the victim's voice deserves to be heard. After all, it's the victim who bears the real brunt of the offences committed against him or her. My lady, that is where there's a victim, where we can still ask of the victim to tell us. In this particular instance, we can't. But we have victims, my lady. Victims that are suffering, victims that are grieving. My lady, in this particular matter, Tabete, although the court in Tabete indicated that the victim should have a voice, in that particular matter, my lady, the court made it clear that the victim's voice are not decisive. Even if, my lady, and in that particular matter, the victim's forgiven a family member that raped and sexually assaulted her over a period of time, they were still staying in the same house, and the victim said, no, I've forgiven my grandfather. I've forgiven my stepfather. The court said, I understand that you've forgiven that, but that is not decisive. The court will still deal with the gravity of the sentences. Lady, may I, in paragraph 50, interpose to submit that forgiveness does not imply necessarily that the impact of the crime on a victim is any less severe than with a victim who does not forgive the accused. This, for instance, my lady, is borne out in the present matter by the evidence of Barry Steenkamp. In relation to the aspect of forgiveness, it's admitted that it's clear on his evidence that the impact of the death of the deceased remains extremely severe, even though the mother of the deceased has expressed forgiveness in the way that she understands it and to protect herself from getting sick. Needless to say, my lady, Mr. Steenkamp indicated that the accused must nonetheless pay for the crimes committed. Justice must still be properly administered or served despite an expression of forgiveness. Forgiveness, my lady, has more to do with a person forgiving than with a crime. We've clearly heard from Mr. Steenkamp that Mrs. Steenkamp had to forgive for her to carry on. My lady, but we've seen Mr. Steenkamp giving evidence. Although there could be forgiveness, my lady, there is still that need for the courts to do its duty with the utmost respect and to sentence accordance to the crime that was committed. My lady, we say in paragraph 51, and that is a fact. It's rare to find testimony, my lady, showing such devastation that was as experienced by the relatives of the deceased, as given by Steenkamp and Kim Martin. My lady, may I just remind the court of Kim Martin's evidence when she gave evidence in the first matter. The court will remember they're driving to work. They're listening to the radio. They heard over the radio that Oscar Pistorius has killed his girlfriend. Her first thought is, I hope he's cheating on Reva. And then, lady, she said, everything changed. Her whole life changed. she explained how they drove back to her mother's house, how they got to her mother's house, her mother was crying, she knew there was something wrong, how they had to go to the funeral. My lady, and the evidence that struck me by Mr. Steenkamp is when I asked him what happened on the day. No parent deserves, my lady, to get a phone call, to get back home, to drive and think, what's going on? Is it one of the animals that died, or is it? But I heard Riva's voice. And my lady, when he said, it was just chaos. It was chaos. I just wanted to see my brother. My lady, that is what the courts are there for, with the utmost respect and as a duty, to protect society from this happening. And when it happens, my lady, to show that the courts will never be lenient on any crime that caused that grief to any victim, my lady. My lady, we refer in paragraph 52 to Isaac's matter, where Judge Davis, in 2002, my lady, expressly held that there are 4 central factors in imposing a sentence, being the offender, the offense, the community, and the victim. We quote Judge Davis, "There's an unfortunate tendency for presiding officers to invoke the well-known triad of circumstances as set out initially in S versus Zinn, almost as a ritual incantation to a query as to the justification for sentence. The dictum of Room J.A., as he then was in Zinn's case, serves to set out the elements which require careful consideration before punishment is imposed. Indeed, this so-called triad itself reflects a somewhat outmoded view of punishment, in that it omits to take account of the specific interests of the victim, which might well be different from those of society." Lady, we have in the past argued that the victim's rights should be discussed as part of the interests of society, but it cannot still be viewed as such, my lady. In this particular matter, society at large would sit back and would experience, as Judge Leach put it, a human tragedy of Shakespearean proportions. But, my lady, the court heard the victims. The court seen the grief of the victims. And their rights should get the same weight as all the other 3 factors. My lady, when we deal with remorse and rehabilitation in paragraph 53, and we're back at Machichi, the appeal court described the essential nature of remorse, the Supreme Court of Appeal, Melanie, described the essential nature of remorse and what the factors are which are indicative of genuine remorse. Lady, and there we quote, "There's a chasm between regret and remorse. Many accused persons might well have regret their conduct, but that does not without more translate to genuine remorse. Remorse is a gnawing pain of conscience for the plight of another. Thus, genuine contrition can only come from appreciation and acknowledgement of the extent of one's error. Whether the offender is sincerely remorseful and not simply feeling sorry for himself or herself at having been caught is a factual question." My lady, the court dealt with remorse in the judgment in sentence earlier. The court referred to the accused's conduct shortly after the deceased was killed. My lady, I argued then, and I do it with respect now, that any person having just killed someone would feel remorseful, would not have wanted to do it, would feel sorry. Having killed Riva, I'm sure he thought, why did I do it? She's not there anymore. But, my lady, real remorse real remorse, would have been the accused taking the court into its confidence, telling the court why I fired those shots, why I acted in the way I did, so that the court can accept that, my lady. We don't have that. We had the opportunity, but we don't have that. My lady, I have to quote this, I have to just follow this whole quote. It's to the surrounding actions of the accused, rather than what he says in court, that one should rather look. In order for the remorse to be a valid consideration, the penitence must be sincere, and the accused must take the court fully into his or her confidence. We don't have that, my lady. We have an accused whose version was rejected. We have an accused, my lady, who in May 2015, in the report by Bayi, thought that he was not even a criminal. He did nothing wrong. Then something happened, and there's no way out. The SCA is pronounced on the crime. We could not approach the Constitutional Court. That was refused. I accept the verdict. But, my lady, acceptance of the verdict, with the utmost respect, my lady, is not. The penitence must be sincere, and the accused must take the court fully into his or her confidence. Until and unless that happens, the genuineness of the contrition alleged to exist cannot be determined. After all, before a court can find that the accused person is genuinely remorseful, it needs to have a proper appreciation of, inter alia, what motivated the accused to commit the deed, what has since provoked his or her change of heart, and whether he or she does indeed have a true appreciation of the consequences of those actions. Now, the first question, what motivated him, we don't know. The court made a finding, but not on what he said, on the circumstance. The court rejected his evidence. So did the SCA. What has since provoked his or her change of heart? My lady, I don't think it was a change of heart, but if we have to take into account what Professor Scholz testified, it must be the SCA decision, and it's now there. I have to. I just have to. There's no other way out. But that, my lady, that is not remorse. My lady, we also refer to Nkuma and others, my lady, where the description of genuine remorse and the factors to be considered was endorsed by the same court, my lady. In S versus Van Rensburg, my lady, at paragraph 55, a very recent decision, 2015-1, the court observed, the first step to a rehabilitation is to acknowledge a wrong committed, and that if the accused does not admit wrongdoing, even after conviction, there is no sign of remorse. There's a difference, my lady, with the utmost respect. I've caused her death, and I've murdered her. I've caused her death is not the same as I've murdered her. For remorse, one needs, I've murdered her. This is why I'm sorry. This is why I did it. Without that, my lady, there can be no remorse with the utmost respect. In paragraph 56, my lady, we submit that in the absence of true remorse, that the absence of true remorse is indicative of an accused having no insight into his or her conduct of committing the crime, and thus suggests that the chances of or prospects of rehabilitation are remote. For if there is no acknowledgement by the accused of wrongdoing, that is, of actually having committed the crime in question, what is there in the mind of the accused that he would need to be rehabilitated from? Lady, and with the utmost respect, my lady, what is important here is we have an accused that whose evidence was rejected. We'll come to the SCA's view on his credibility. We have an accused, my lady, that in May 2015, in talking to the psychologist at the prison, had no insight, none whatsoever. Now something happened, but he hasn't taken the court into his confidence. We don't know what. It's just to prepare himself for sentence. He has to. I have to say that I now accept the sentence because the court will re-sentence me. But, my lady, The court has heard nothing. In fact, my lady, what the court has heard is that an accused elected to give an interview to the TV, but not take this court into its confidence. That's disrespectful to the courts, that's disrespectful to the victims of this crime, it's disrespectful to the deceased. My lady, in Janti, the court pertinently held, seeds of rehabilitation can, in a manner of speaking, germinate only if the convicted person himself has, first and foremost, expressed contrition for his criminal wrongdoing, thereby accepting the gravity of the criminal act of which he has been convicted, and commits to return to the path of rectitude. Without expression of contrition, any hope of rehabilitation becomes illusory and thus an unrealistic expectation, and not merely a speculative hypothesis. We say in paragraph 57, my lady, it's respectfully submitted that applying these principles to the present matter, the accused cannot be said to have true remorse and consequently be ripe for rehabilitation, where the Supreme Court of Appeal, in this case on appeal, affirmed that the accused was a very poor witness whose evidence was so contradictory and vacillating and untruthful as to his state of mind when he fired his weapon, killing the deceased, and that therefore, and these are the important findings, my lady, one really does not know what his explanation is for having fired the fatal shots. One does just not know his true explanation for firing the weapon. And he never offered an acceptable explanation for having done so. We respectfully submit, my lady, that in the present matter we are still in the dark as to why the accused fired the fatal shots. Coming from him, my lady, we don't know, as the accused has chosen not to take the court into its confidence. This, with respect, is a significant aggravating factor and nullifies the accused's purported remorse and contrition, which Dr. Jonathan Scott testified that he has. The aspect is compounded by the fact that Dr. Scott still referred to the accused as having taken the life of the deceased without intending to do so. And he said that. And, my lady, we also refer to Ms. Bai's report, where she wrote, he fails to identify himself as having committed a crime, as his intentions were to protect the victim. My lady, may I just pause? If the accused informed this court what happened between May 2015 and now, why he changed his mind of not having committed a crime and accepting that he murdered the deceased, that would have been something to argue on by the defense, but we just don't have it. We have the fact that he fails to identify himself as having committed a crime while serving a sentence, my lady. And he still hasn't done so, not by himself. We submit, my lady, that in S versus Martin, although the accused pleaded guilty in that particular matter to counts of murder and attempted murder, and he never testified, the court, as per Fleming, Deputy Judge President at the time, held as follows, my lady. To determine sentence, particularly for a more serious crime, there's not a more important question than, why did you do it? It's hardly excusable to ask an accused how many children he has and to omit the crucial, why did you do it? Only in an exceptional case will the answer to that question not be dominant, and getting to understand the influences on the accused and generally to discover the true degree of moral reprehensibility. With no known answer to that question, the accused is at risk of appearing to have acted without reason and to deserve the harshness which accompanies wanton criminality, which is executed without anything which reduces moral reprehensibility. An accused assumes some risk by failing to testify, in that there is then often a preclusion of opportunity to give an answer to that crucial question. Counsel's speculation without a factual basis is not an equivalent. My lady, and that is exactly what we have. We will have Mr. Roux that will give the court lots of reasons why that happened, of being vulnerable, walking up and down, being scared, why he did it. My lady, but it's now done. The judgment was changed into one of murder, dolus eventualis. It's now up to the accused to take this court into his confidence and to explain to this court. He hasn't done so, my lady. He hasn't done so. But the court knows that he has given a version. Whilst awaiting this procedure, whilst awaiting sentence, has given a television interview explaining himself, talking about that night. We at paragraph 60, my lady, we say that rehabilitation may also be inadequate when the other sentencing considerations are assimilated into the scales. In such a situation, rehabilitation will not be considered of overriding importance. My lady, and that's, this principle is important. And Lister, my lady, that we referred to here, about prison and about sentence, and about all the arguments we've had by Dr. Scholes about the conditions, is of utmost importance. In Lister, my lady, the court said, prison, one knows, is not a congenial place, and the conditions may well be less than ideal for psychotherapy. But then, a prison is primarily an institution of punishment, not cure. As the court of quo was at pains to point out, the approach of a sentencing officer is not the same as that of a psychiatrist. The sentencing officer takes account of all the recognized aims of sentencing, including retribution. The psychiatrist is concerned with diagnosis in rehabilitation. To focus on the well-being of the accused at the expense of other aims of sentencing, such as the interests of the community, is to distort the process and to produce, in all likelihood, a warped sentence. My lady, having known that we would refer to Lister, I asked Professor Scholes on 2 occasions, "You've only looked at the accused, nothing else." And he said yes. And my lady, that's what the court said in Lister. The court has a different duty. My lady, the principle enunciated in Lister was endorsed by the Supreme Court of Appeal in a recent decision of S versus SD. My lady, that's a 2015-2 matter, my lady, by Justice Brandt, where the matter was articulated as follows. It must be remembered, however, that medical experts by nature of their profession have a different perspective. Their purpose is to diagnose, to heal, and to rehabilitate their patients. As a rule, they do not have to consider their perspective, which the courts are obliged to keep in view. Our sentencing function is quite different. Apart from rehabilitation, we also need to have regard to the other interests, such as prevention and retribution. To focus exclusively on the well-being of the accused person is likely to result in a distorted and warped sentence. Lady, whilst I referred to Lister, I had to pause and to indicate to the court that whilst the accused was in prison, he was allowed visits and access to his private doctor. He was allowed visits and access to his private psychologist. He was allowed visits by his pastor, by family. Dr. Scholes indicated that he received counseling by Dr. Hartzenberg. whilst being in custody. My lady, in paragraph 62, we refer to a comment by Blanche in his treatise on sentencing. May I refer to S versus Rowe and another? It's a 2010 decision, my lady. The majority of the Supreme Court of Appeal, per Majid, acting Judge Appellant as he then was, my lady, citing with approval, Lister found that to elevate the personal circumstances of the accused above that of society in general and the victims in particular would not serve the well-established aims of sentencing, including deterrence and retribution. And in S versus Vilakazi, my lady, in 2009, Nugent J.A., for a full bench of the SCA, pointed out that in cases of serious crime, the personal circumstances of the offender by themselves will necessarily recede into the background. My lady, we're dealing with a very, very serious offence. I'm not saying that the personal circumstances of the accused should not be taken into account. But in this particular instance, my lady, it recedes into the background. In the SCA decision of Combrink, my lady, the appeal court was critical of the court of quotes approach of focusing exclusively on the mitigating factors instead of balancing them with the aggravating factors, and in particular of overstating the personal circumstances of the accused, whilst virtually ignoring the personal circumstances of the deceased and the gravity of the offence. That is such an important judgment, my lady. Whilst virtually ignoring the personal circumstances of the deceased and the gravity of the offence. My lady, in what I've heard in the evidence that was laid on behalf of the defence, the deceased in this matter disappeared. Lady, we've done a trial. We were here for many a day. One get the feeling that the personal circumstances of a deceased just disappears. The court said in this particular matter, my lady, in Combrink, that the court should take into account who she was, what dreams she had, because, my lady, she had no contributory factor in her death. It was all the accused murdered her. She wanted to go back. She wanted to look after her father and mother. She wanted to be a model. She was on TV. Those things, my lady, is just as important as the personal circumstances of the accused, the personal circumstances of the deceased. The Court of Appeal added, my lady, that the loss of life would self-evidently have had a negative impact on the family of the deceased, and that life was the most valuable asset of the deceased, which had been taken away from him. May I pause? Life was the most valuable asset of the deceased. It does not matter if the accused thought she was an intruder. Is the intruder's life not important? Did he not think of an intruder's life? He didn't. He intentionally, in his view on the argument of the defense, intentionally killed an intruder. That's not important. As long as we can just cover in our argument that he never thought he was killing Riva, then we're happy. But you can't do that, lady. What happened is, the consequence of his actions, the consequence of his intention, is that the deceased lost the most valuable asset she ever had, this is her life. She can never walk in court, my lady. The Court of Appeal affirmed that murder is a very serious offence, and that the resort by the accused to his firearm and the killing of the deceased was gratuitous. My lady, I had to look up the meaning of gratuitous. And the best way of explaining it for me is the use of his firearm in the killing of the deceased was excessive and unnecessary. It's exactly what happened here, my lady. I cannot think of a more excessive use of a firearm. By arming yourself in your bedroom, walking to the bathroom, gun at the ready, and thinking that if there's somebody in the bathroom, I'm going to shoot, and when there was, he did. It was totally excessive. Firing 4 shots through that door, my lady, that tore up the body of the deceased, was in fact gratuitous. My lady, in the matter that Mr. Roux referred to, Hewitt versus the state, we don't have it with us, my lady, but if you would want a copy of it, we'll make it available immediately through your clerk, if you would want to have that particular judgment. Scrupulous care must be taken not to overemphasize the appellant's personal circumstances without balancing those considerations properly against the very serious natures of the crimes committed, the aggravating circumstances, and the consequences for the victims and the interests of society. Lady, this is a well-published matter of a tennis coach that is well advanced in years, that committed the crime lots of years ago and was sentenced to direct imprisonment. Why should this accused escape direct imprisonment? My lady, we deal with anticipation of what the defense might have argued. We deal with the factor of dolus eventualis and dolus indeterminatus in the determination of an appropriate sentence. Firstly, my lady, we submit that dolus eventualis is not per se a mitigating factor. Rabi and Strauss note with reference to Dladla and andere that the correct approach is whether in a particular case, in the light of all the surrounding circumstances, the absence of direct intent can be regarded as mitigating. My lady, we referred in paragraph 66. It's perhaps more important to refer to Dladla, in where Dladla endorsed the finding of Minis, affirmed that what is required in determining whether dolus eventualis can be a mitigating factor is a gradation of the degree of foreseeability. This is by reason of the fact that dolus eventualis is an elastic concept. On the one extreme, it can border on negligence, especially culpa lata, and on the other side, on dolus directus. Janssen J.A. added that it's not the ex post facto objectively determined foreseeability that is involved in the gradation inquiry, but the subjective contemplation of the doer in the commission of the act, whether he or she regarded the possibility as a faint or strong possibility. Lady, we don't know. We really don't know. He has not given us an acceptable version. What we do know, however, is the accused testified that he did not want to shoot a warning shot into the shower because he was worried that the bullet might ricochet back and hit him. But he fired 4 shots through a door into a small cubicle. My lady, and then I have to refer to the SCA judgment. At paragraph 50 of the SCA judgment, as a matter of common sense, at the time of the fatal shots were fired, the possibility of death of the person behind the door was clearly an obvious result. And in firing not 1, but 4 shots, such a result became even more likely. But that is exactly what the accused did. A court blessed with the wisdom of hindsight should always be cautious of determining that because an accused ought to have foreseen a consequence, he or she must have done so. But in the present case, that inference is irresistible A person is far more likely to foresee the possibility of death occurring where the weapon used is a lethal firearm, as in the present case, than, say, a pellet gun, unlikely to do serious harm. Indeed, in this court, counsel for the accused, while not conceding that the trial court had erred when it concluded that the accused had not subjectively foreseen the possibility of the death of the person in the toilet, was unable to actively support that finding. In the light of the nature of the firearm and the ammunition used and the extremely limited space into which the shots were fired, his dividends is understandable. But having quoted the Supreme Court of Appeal, I have to refer back to Minis. Minis, and that's why I quoted it. Paragraph 66, Janssen J.A. said, added to this, that it's not the ex post facto objectively determined foreseeability that's involved in the gradation inquiry, but the subjective contemplation of the doer in the commission of the act, whether he or she regarded the possibility as a faint or strong possibility. We, in paragraph 68, my lady, respectfully submit that the degree of dolus eventualis which the accused had in the present matter bordered on dolus directus and not on negligence. Then, my lady, we deal with dolus indeterminatus. We respectfully submit, my lady, that in a present matter, the Supreme Court of Appeal held that although a perpetrator's intention to kill must relate to the person killed, this does not mean that the perpetrator must know or appreciate the identity of the victim. The court explained, a person who causes a bomb to explode in a crowded place will probably be ignorant of the identity of his or her victims, but will nevertheless have the intention to kill those who might die in the resultant explosion. Reverting to the lexicon of a lawyer, this is known as intent in the form of so-called dolus indeterminatus, the killing of an indeterminate person. But, my lady, if there was a bomb, if somebody placed a bomb and a bomb exploded and killed 50 people, you'll be convicted of 50 counts of murder, not of indeterminate people, but of the identity of those people, because that's what he did. Although he had dolus indeterminatus as far as that was concerned, he did not care who he was killing. He killed that particular person. That's what happened here. Although Mr. Rook can argue that he thought there was an intruder, and that must in some way be a mitigating factor. How, I don't know. But the mere fact that he thought there was an intruder should be a mitigating factor, I don't see. But that doesn't make sense. But that does not necessarily mean that this accused is not guilty of the murder of Reva. He's guilty of the murder of Reva. He killed her. My lady, the court in the SCA correctly held that dolus indeterminatus is not a form of intention apart from dolus directus and dolus eventualis. It's merely a label, meaning that the perpetrator's intention is directed at a person or persons of unknown identity. A perpetrator can therefore act with dolus indeterminatus simultaneously with dolus eventualis. The trial court referred to Snyman, and we deal with that in paragraph 71, my lady. 72, my lady. When we drafted that, we had to anticipate what the arguments would be, so it reads, it is thus submitted that if the argument were to be advanced that the accused did not appreciate at the critical moment that it was Reva Steenkamp who he fired the fatal shots at, but an indeterminate person, and that consequently ought to be regarded as a mitigating factor on the question of what the accused foresaw, our contention is with respect that such factor does not detract from the fact that dolus eventualis in this case borders on dolus directus, given the Supreme Court of Appeal finding in paragraph 50, and there's still no acceptable explanation for why the accused fired the fatal shot. More than one, 4 shots. It's accordingly respectfully submitted that any argument pertaining to mistaken identity of the victim cannot constitute a mitigating feature. The fact remains that the person was intentionally killed by the deceased for reasons that only the accused knows. but which the accused has not given an acceptable account of. As the Supreme Court of Appeal found, the accused, no doubt, in firing the fatal shots, foresaw that whoever was behind the toilet door might die, but reconciled himself to that event occurring and gambled with a person's life. This constituted dose of injustice on his part, and the identity of the victim is irrelevant to his guilt, my lady, and irrelevant to sentence. We deal with the nature and gravity of the offences, my lady. The deceased was killed. She's dead. She will never realize her dreams. Her greatest asset, namely her life, was taken away by the accused. The deceased did not contribute to her death. She innocently, on the court's finding, went to the toilet in the early morning hours. The deceased died a horrific death. We respectfully submit that the court, in fact, accepted the evidence of, as he then was, Captain Mangena, that she was standing in the door, in front of the door, facing the deceased. That was his evidence, my lady. The court accepted his evidence. So his evidence is, when the accused fired the shots, Riva was standing in front of the door, facing him, where the first shot hit her in the hip, and then the other shots were fired. The court should, with respect, take into account that the deceased had nowhere to go, and that one after the other bullets ripped through her flesh. The accused had been convicted of murder, my lady. He intentionally killed the deceased. However one want to explain it, the finding is the accused, with intent, killed the deceased. Although he may have thought it was an intruder, the finding is he's guilty of the murder of Riva. This court, my lady, in Tatane's matter, found that taking the life of a fellow human being is always a serious offence which lead to outrage and demands heavy punishment. We refer to Makwanyane and another Constitutional Court decision where the court held the need for strong deterrent to violent crime is an end to the validity of which is the need for strong deterrent to violent crime is an end, the validity of which is not open to question. The state is clearly entitled, indeed obliged, to take action to protect human life against a violation by others. In all societies, there are laws which regulate the behavior of people and which authorize the imposition of civil and criminal sanctions on those who act unlawfully. This is necessary for the preservation and protection of society. Without law, society cannot exist. Without law, individuals, society have no rights. The level of violent crime in our country has reached alarming proportions. It poses a threat to the transition to democracy and the creation of development opportunities for all, which are primary goals of the Constitution. The high level of violent crime is a matter of common knowledge. Those who engage in violent crime should be met with the full rigor of the law. My lady, may I pause here and just argue, as Mr. Roux did. The accused thought there was an intruder in the bathroom, in the toilet cubicle. He walked there and fired 4 shots. That cannot be a mitigating factor. I just cannot see how the fact that he did not think it was Riva, but intruder can ever be a mitigating factor, except if you say the life of intruder is less important than the life of Riva. You say that, but I don't think Mr. Roux will ever say that. But that is the only way one can argue that it's a mitigating factor. Without that, we can never argue that it's a mitigating factor. She is, after all, she is the one that was shot. Well, lady, it's almost with respect odious to repeat that murder remains the most reprehensible crime that can be committed because of flagrant disregard it entails for the sanctity of human life. There's moreover an outcry from society against such crimes. Society demands that robust sentences must be imposed. My lady, before I go to the conclusion, I feel duty-bound to refer the court to a specific aspect in the judgment by the Constitutional Court. At 451, my lady, page 451, paragraph 56.
Judgment by the
That is by Justice Leach in the
Supreme Court of Appeal. I thought you said the Constitutional Court.
No, Supreme Court of Appeal. If I did, I apologize. I'm sure I did, but I apologize. Paragraph 56, my lady, where the court referred the matter back for sentence. That's perhaps why I refer to the Constitutional Court, my lady. Quite properly, particularly in the light of the Constitutional Court judgments in Nabulisa and Bogarts, as the matter must be sent back to the trial court for sentence to be imposed afresh. In doing so, obviously, whatever punishment has already been served by the accused in respect of the incorrect conviction of culpable homicide will be taken into account. That the court has said. And I feel duty-bound to indicate that that was a finding. My lady, in our conclusion, we argue that the minimum sentence of 15 years ought to be imposed. If, however, my lady, this court will find substantial and compelling circumstances that the court would feel justify a lesser sentence, we argue for long-term imprisonment that should be imposed. My lady, I've argued that I think that 15 years imprisonment ought to be imposed as a minimum. I don't think the life of Free Steenkamp was a minimum, my lady. The matter is so serious that I've taken everything into account that have been argued, and that still remains to 15 years, my lady. My lady, now I have to deal with one specific aspect, and that is the aspect that I touched on in terms of the photographs. My lady, this court made a finding that the photographs of the deceased and certain of the photographs should not be viewed. Mr. Roos indicated that it's time for him to do certain things. The witness that the state called said it's time for the world to see those photographs. So we apply, my lady, for the lifting of that order, and so that those photographs can, for once and for all, be viewed by everyone. And, my lady, we will not show as the photographs that Dr. Simon dealt with. Those are not the ones, my lady. But our application is, in particular, Exhibit E. And it's photograph numbers 135, 136, 137, 138, 139, 140. I have, my lady, in the break, had a consultation again with the parents. I have shown them the photographs, and they asked me to bring this application serious, to bring a serious application for this order. The order that we seek, my lady, is that the court will allow those photographs to be made available publicly. My lady, as I indicated, I've not had the heads of argument of the accused before I started arguing. Will the court allow me just to page through them and where I made notes to deal with one or two aspects, my lady, of the heads of argument of the accused?
You say you need more time.
No. May I stand here and page through them? So I'll just be paging. I've made notes, and I'll decide on what I would address. My lady, at paragraph 9 of the heads by the accused, it's not our argument that the SCA dealt with factual findings, but the SCA, in fact, said that using the factual findings of this court, it's as good a position to make inferences from the proven facts as he did. And that, my lady, are the inferences that we have referred to in our heads. So it's not a new set of facts, my lady, but inferences from proven fact. My lady, I have a note in, whilst Mr. Roux was arguing, I made a note. May I just but anyway, where Mr. Roux at paragraph 13.
1.3.
1.3, my lady, yes. Where Mr. Roux refers to the SCA judgment in paragraph 30. I made a note that one should just read that paragraph further. The paragraph reads, my lady, I've emphasized that the trial court's consideration of dolus eventual is centered upon whether the accused knew that the person in the toilet cubicle was Riva, and its conclusion that dolus eventualis had not been proved was premised upon acceptance that as he had thought Riva was in the bedroom, he did not foresee that she was the person in the toilet. Simply put, the finding was that the accused did not realize that was Riva in the toilet. He did not foresee that the action of shooting could cause a death and could not be held guilty of a murder. But 31, this finding goes to the heart of it, and then he deals with dolus indeterminatus. So all it means, my lady, is that identity, the identity of the deceased in this matter, is not a crucial aspect. And that's what the court dealt with there. My lady, this is a very unprofessional way of dealing with heads, but that's the only time I have available. In paging it, I made some notes. Uh, 17.2.1. The SCA did not consider the trial court's finding that at the time of the shooting, the accused believed that the person in the toilet was an intruder and that the deceased was in the bedroom. My lady, my comment is, with utmost respect, it does not make a difference. It does not detract from the seriousness of the crime. The person that's dead is Riva Steenkamp. We have dealt with 17.2.4, my lady, the Ferreira matter. That's distinguishable on the facts. So totally different facts of an abusive relationship where a partner had no way out but to get two people to kill her partner. My lady, in 17.3, Mr. Roux argues that the appeal court did not reconsider the findings of the flight response, but we've referred the court to not only credibility findings, but also the fact that the accused armed himself, walked there, approached the danger with the intention to shoot if there would somebody be there. That's a finding, my lady, of the appeal court. That's a finding that the court should give effect to, with utmost respect. And that is, he armed himself with the intention to shoot if there was an intruder in the bathroom. And when there was, he did. Those are the findings of the SCA. And I say it with utmost respect, that this court should give effect to in a sentence, my lady. My lady, as far as 17.5 is concerned, the comment that, or my response to that 17.5.1 would be, my lady, that the Supreme Court of Appeal made findings on 3 occasions that it is unclear why the accused fired the shots, as he explained he did. And those are findings, my lady, with utmost respect, that this court will have to take into account. My lady, as far as paragraph 20.2 is concerned, my lady, it doesn't mean that I do not have any difficulties with other paragraphs.
What are the...
20.2, my lady.
What's the page?
Page 20, my lady.
Page 20. Thank you.
I found that interesting. The accused has punished himself and will punish himself for the rest of his life far more than any court of law can punish him. My lady, it's unclear how the accused punished himself. But I'm convinced that any person that stands accused of murder and is convicted of murder feels that he's done himself in. That wasn't the thing to do. How he punished himself, I don't know, my lady. But what I do know is, I know how Mr. Barry Steenkamp punishes himself to feel the pain. That is a broken man that gave evidence before this court. My lady, at paragraph 27, page 24, my argument here is, my lady, our argument is that the accused's version was rejected by this court. The appeal court made, on 3 occasions, findings on the credibility and a probable or possible version of the accused and said that none existed. Then paragraph 30, my lady. Paragraph 30, my lady, I really just don't understand. We respectfully submit that Mr. Steenkamp's pain was compounded by being exposed to an incorrect case presented by the state that the accused had a direct intent to kill the deceased. How can that be said? Based on what? It's a respectful submission based on what, my lady? Not on the evidence at all. Not evidence led before this court. Not on the evidence of Mr. Steenkamp. Not on the evidence of Kim Martin. So on what would they base that? How would they be able to submit something that there is just no basis for whatsoever? Because, my lady, as we argued, if that was true, one would have expected anger towards the accused by Mr. Steenkamp, there was never anger towards him. There was grief we saw, shaking hands we saw, but never anger. The best he did for himself as a father said, he must pay. That's all. He did not tell the court to send him away forever or anything like that. So he must just pay. Now that's not anger or hatred because he would think that the state would present a case of direct intent to kill. It just does not follow. My lady, as far as Professor Scholt's evidence is concerned, and that's dealt with at page 26, we have dealt with most of it in our heads. But we reiterate our argument that it is one-sided, it's not objective. That was perhaps the purpose of it. If it's the purpose of it, let us just identify it as one-sided and not objective. What bothers me most is by his report and sweeping statements about incarceration and solitary confinement. That affected the objectivity and the value that the court could give to Professor Scholt's evidence. My lady, may I refer to page 36? There is just no way, my lady, and I say it with the utmost respect, and I argue that the court will take into account that the accused's perception was that he and the deceased were in danger and that was fortified by open bathroom window, not on the SCA decision. On the SCA decision, in dealing with putative self-defense, the court dealt with it quickly and decisively, indicating that there is no chance of it's one of those things you mark it and you can get it at any moment if you're not on your feet. But I will get it now. The best the accused can do, as far as paragraph 70 is concerned, is to follow the findings by the SCA. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom, and when there was, he did. In doing so, he must have foreseen and therefore did foresee that the person he was firing at behind the door might be fatally injured, yet he fired without having rational or genuine fear that his life was in danger. And that's paragraph 54 of the judgment, my lady. And in the judgment as well, Justice Leach made it clear that in the accused's evidence, we testified that he never intended shooting at the person that might have been the danger. excluded him from period of private defense. Because that is the one aspect that one would expect in period of private defense. And that would be paragraph 53, my lady. The immediate difficulty that I have with the accused's reliance upon period of private defense is that when he testified, he stated that he had not intended to shoot the person whom he felt was an intruder. This immediately placed himself beyond the ambit of the defense. Although, as I've said, his evidence is so contradictory that one does just not know his true explanation for firing the weapon. But it's just outside the scope of putative private defense. But lady, at 70.7, page 37, in fact 70.8, the defense would want the court to take into account the downward trajectory. We go a bit further, my lady, say the court accepted the evidence of Mr. Mangena. Mr. Mangena testified on the angles of the downward trajectory, but more importantly, is evidence that the deceased stood in right against the door facing the deceased is a fact that this court accepted. And that is perhaps more important than the downward trajectory, my lady. We dealt with in our heads that the mere fact that he could have aimed higher or lower has to do with the difference between those directors and those provinciales. But the more important aspect is the evidence of Captain Mangena. My lady, where we deal with paragraph 76, page 39, there's a submission that the aggravating factors resulting from the finding of the SCA do not outweigh the reduced moral blameworthiness. My lady, I just don't see them at reduced moral blameworthiness. Not on the facts that we have before us. The facts we have before us, my lady, that I've dealt with in paragraph 10, 13, 14, and 19 of our heads is a person with intent approaching the bathroom and firing the shots through the door. My lady, that was a quick glance at the heads of the defense. I then conclude by saying, my lady, that we feel that a long-term imprisonment and the minimum sentence should be imposed. My lady, may I inquire if the court will make an order today about the photographs, or will the court make it?
I've got a question to ask. Are you not asking this court to extend the scope of these proceedings?
No.
We are here for resentencing,
Yes, my
for
lady.
sentencing afresh.
Yes, my lady. The court can, at any time up until sentence is passed, the court still has the power to deal with any order made by the
No, I'm not saying I can't do it. I'm
Yes.
saying, are you not extending the scope of these proceedings? The purpose of these proceedings
Yes,
are to sentence afresh.
yes, my lady. Yes, my lady. My argument to that is, my lady, in leading evidence in aggravation of sentence, a witness requested this court to allow photographs to be made available as part of the process. It is inherent into as part of the process. It's sentence. The father gave evidence. He requested this court to make that available as part of this process, my lady, not as any other process. In sentence, that's what he wanted. So, my lady, if those were perhaps evidence led in the previous trial, and we cannot revisit it, that I would have said would be extension of the scope. But it happened now, my lady. It happened whilst we're busy with the resentencing of the accused. A witness testified now. And therefore, my lady, I'm confident that the court, and I say it with utmost respect, has the power.
No, I didn't say I didn't have the power.
Yes. And also confident that it's not outside of the scope of these proceedings, my lady. It's part of the, because, my lady, may I argue that part of my argument is that the court should have access to the photograph. The court itself should perhaps revisit, like Mr. Roux wanted us to revisit certain things. The court should revisit certain things in sentencing. If that is my argument, that 4 bullets tore through a body, that the court should take that into account as an aggravating factor, then I've made this part of the scope of these proceedings, my lady. And I have. I've said the court should take into account what happened to her while she's in that cubicle. It's part of sentence. That's my argument on the scope of the proceedings. It happened during sentencing a fresh sitting, and I agree that the court has the power to do that. I just say that it's within the scope.
Thank you.
Yes, my lady.
Thank you. Yes, Mr. Roux.
Thank you, my lady. I won't be long. My lady, as to the application, I think it should be a substantial application. There are so many interests. You're the upper guardian of children. Would that be in the interest of children to look at the photos? I understand what Mr. Steenkamp is saying, but it's a separate application with separate merits, and it needs separate input. And the court's the upper guardian, and I'm not saying the court does not have the power, but I don't think it's the appropriate stage. You're here for resentencing. That's a proper application that can be made, and submissions made, affidavits filed, and interested parties can then be present. But it's got wide ramifications, and I don't think it's appropriate to consider it as part of this. As the upper guardian, must children look at it? How will we stop children from looking at, and what is going to be achieved? I think it must be properly ventilated by all parties concerned, my lady, and this is not appropriate. The appropriate time. My lady, I will do a reply in the true sense of a reply. The state says that our paragraph 31 does not make sense, where we said that the pain of Mr. Steenkamp is exacerbated by the fact of the state scenario. Well, I have two answers. The first answer, if I may read paragraph 18 of the Supreme Court of Appeal judgment, then it will become clear.
1 minute, I got distracted. What paragraph were you referring to?
I'm sorry, there was reference to paragraph 31 of my heads of argument, page 25.
31.
31, page 25, paragraph 31, my lady. And he says that.
Thank you.
And my lady, two answers. One is, if I may read paragraph 18. Paragraph 18 of the Supreme Court of Appeal judgment, the first part says the following. It is not necessary to examine the accused's credibility in any greater detail for purposes of this judgment as, despite the deficiencies, the trial court concluded that it had not been shown that the state's version that there had been an argument between the accused and the deceased which had led to her fleeing to lock herself into the toilet and him then shooting her through the door was true beyond a reasonable doubt, and that the state had not shown that the accused had fired at the toilet door for any reason other than he had thought there was an intruder behind it. He says that's the trial court's finding, and it's not for me to reconsider that. Now, that's important. The whole state's case was premised on Dairos directives on this alleged, purported argument and fleeing. When Mr. Steenkamp gave evidence, he was stopped. He said, I still believe there was an argument. And that's the point we're making. That's the point we're making by presenting that case, which had no merits, that you exacerbated the emotions. It's in that regard. Then there was reference to paragraph 70.6 of our heads of argument, page 36, where it was his perception that he and the deceased were in danger was fortified by the following. Those are the court's findings, the trial court's findings, and those findings were not disturbed or reconsidered by the Court of Appeal. That's where it comes from. It's not something that we dream up. Of course it's important, it's part of sentencing. My lady, Professor Scholes is now criticized to say, you only look at the accused. We have to bear in mind that the same facts remained. It's a matter of interpretation on the facts. There was no new evidence before the Supreme Court of Appeal. So it's already all the other factors relevant to sentencing are before the court, and the only outstanding thing was what has since happened to the accused. It is that perspective that Professor Scholes was asked to say, just do the analytical process and tell the court from what is now the position with the accused. It's not a fresh sentencing report. All those factors are already before the court. It's not a new case. It is just to deal with that aspect. And then you cannot say it's biased. Then you cannot say it's not objective. It is objective. It is only that part and no more. It was submitted to you that the Versaghi case, and I don't want to go too deep into the Versaghi case, it was more to explain to the court what's happening here. That was not a matter that's not applicable. Of course, someone was driving away. He's not in danger. He fired shots when he should not have. It's the same. Then the state says that the accused intended to kill the deceased. Now, we have to be very careful here. It's a constructive intent. I'm talking about the factual intent for purposes of moral blameworthiness, because the deceased remained a party in the indictment. It was not a person unknown or a person behind the door. So when we look at sentencing and moral blameworthiness, we have to look at how did he feel about the deceased and his intentions against the deceased. And then you look at everything in context. And then you understand that is subjected to the legal construction of intent, that you cannot in law escape liability. But that does not mean that his beliefs are just eliminated and negated. They're still there. And that's also in paragraph 18 of the Supreme Court of Appeal judgment. That's the factual finding. And lady, if I carry on, I will abuse the process of reply. Those are really the main points in law relevant to it.
Yes.
Lady, with the utmost respect, we usually...
Excuse me, lady, I'm not
I thought you're done.
sure what the process is.
No. I allow him to reply only to the application. I'm not sure what he was...
Yes, to the application then, of course
Yes.
he's right, Malay. I was not sure. I was still standing and he was talking and I...
I'm so sorry. I
Yes,
thought
thank
you
Thank
had
you.
finished.
No, I am now.
I
Thank
can assure Mr. Roo I will not get up if the court did not recognize me. And he should know that. The court recognized me and that's why I got up. And the court's 100% correct. I want to deal with the application. My argument is, Mr. Roo is not even part of that application. We as counsel, when we don't want to deal with something, we always say, let us bring a substantive application. It's not that complicated, my lady, with the utmost respect. Those photographs were handed in.
What if I agree with him?
Then, my lady, if the court agrees,
Yes.
the court may say it should only be shown in court or whatever. But if the court agrees, my lady, it would be as the other exhibits. My lady, Exhibit E was available to the media, except these photographs were taken out. It was handed in. So all we're saying is, those that we excluded, it was handed in as exhibits. It's a public document. So all we're saying is that it's a public document. The interest that we protected was the integrity of the deceased. Now, the deceased parents are here. They are legally represented as we stand. I've had consultations with all of them. That is their view, my lady. So if there's a substantial application, who would be part of that? Lady, may I just say that if we make it available...
You know, a substantial application doesn't have to be opposed. You know that.
Yes.
Yes.
But, my lady, but then I can answer any question. I'm bringing one. And I can answer any question. My lady, because if we say it will be made available, what people do with it, my lady, they have to bear the consequences. In making it available, we're not showing it to children. The court's not showing it to children. The court can even caution people not to do that. My lady, and I purposely did not want it to be on television or on the screens like we had. It's an application, my lady, just to show what happened to the deceased. It's a public document. The publishers or whoever want to use it, they take responsibility for what they do with it. And I believe they're responsible. From the parents' point of view, my lady, and from the state, we think it's time, as I'm quoting Mr. Roo, it is time that people would see what those bullets did, what this accused did. That's my application, my lady. If there's any other aspect, I'll address the court on it. I'll even take instructions, my lady, because the interested parties here, the court is the custodian of it. The integrity that we wanted to protect was that of the deceased. And, my lady, more so, the mother of the deceased. I brought the application because the mother of the deceased was in court. I didn't want her to see it. That was the protection that I wanted. She's now given her permission. That's my argument. I'll deal with any questions that the court may have, my lady. And I realize it's not an easy decision.
Thank you. I need to, I will think about it.
As the court pleases.
I need to go and get a date when I'll be sentencing.
Yes, my lady.
So for that reason, we shall adjourn. What is the time?
It's 3:45, my lady.
3:45. We shall adjourn just for the purpose of getting the date. If I can't get the date, I'll come back and I'll give the date on Friday.
As the court pleases.
But if I can get it immediately, I'll do so.
We are one of the 22 high-burden countries, and out of that, we're number 6, following countries like India, China, and with huge population.
Cough, night sweats, weight loss and fever, and cough being the most important of those. So, and especially if the cough lasts for more than 3 weeks, then you really have to worry and get tested for TB.
The motivation is to affect behavior change, particularly with people who cough and who may be carrying the bacterium. So encouraging people to use the elbow.
For more on health, join your host Dr. Selo Motaung every Saturday from 9 to 10 a.m.
News Today keeps you informed with news locally and around the world.
When Judge John Hlophe challenged the Supreme Court of Appeal when it sent the matter back and said that there must be an inquiry set up.
We unpack business news.
There's an increase in general inflation in the country.
We give you up-to-date news of the day.
The drugs were seized at several locations in Sydney, including a shipping container sent from Hong Kong. Police say it's the largest haul of illicit drugs in 2 years.
We round up sports news.
Kotata, tell me about the legacy that you would like to build and be remembered for.
Trying to get my foundation running, which is going to focus on, all the sport, doesn't matter disability or able body. So, I'm passionate about sports.
Stay informed every Monday to Friday from 3 to 5:30 p.m. CAT. SABC News.
It's almost 4 p.m. This is News Today, and a warm welcome to you. My name is Pearl Shongwe. Let's take a look at our top stories this afternoon. State Advocate Gerrie Nel asked the High Court in Pretoria to lift the ban on publishing photos of Reeva Steenkamp's body. Multi-award-winning photographer Peter Makubane launched his book called June 16. The book launch marks a series of events hosted to honor the 40-year anniversary of the June 16